Let me bring in, we're going to bring that to you as soon as it begins, but in the meantime, let me bring in Jean Casares to get us all up to speed. And Jean, what's going on here specifically has to do with whether or not it was appropriate and the right thing for the judge back in the 90s to have excluded the evidence that the Menendez brothers had been sexually assaulted by their father.
And it wasn't excluded from the first trial. It came in. That was a mistrial. The second trial, it came in a bit, but it did not come in to the full extent. And so what the district attorney would believe is going to say is that there should be a resentencing here. And this sentence was life without the possibility of any parole. So that is not something that normally would go to resentencing, but he's saying because of new evidence, and he's saying it was a letter that Eric wrote his cousin Andy saying, "I'm scared of my dad coming into the room." Well, new evidence under the law is evidence that wasn't around at the time of the trial, and if the jury had been able to know about that evidence, they could have acquitted them. Well, a Barbara Walters special in 2015 that I found, she had the letter. She had just been sent the letter from the family. She read it on that special. She also said that the trial court in 1993, it was offered as evidence, that letter, and the trial judge said, "I don't see that it specifically is showing sexual abuse at the hands of the father." So we have to see if he addresses that letter and still calls it new evidence. The other is rehabilitation. He says that rehabilitation is an important part of prison and that there has been rehabilitation here. They should get out because of rehabilitation and have that resentencing. But Jake, how many people in prison believe they have been rehabilitated from very violent crimes? And maybe some have, maybe some haven't. But that would be revolutionary for our justice system. And there was a Senate bill in California that was up to be passed in August on this very issue, and they had to shelve it because there was too much controversy from victims' advocates, from district attorneys' offices around the state. And so it'll be very interesting to see what he says in this presser that's just about to happen.
And now let me bring in criminal defense attorney Misty Marris. Misty, there is no dispute that Lyle and Eric Menendez killed their parents. The question at hand here is whether or not in 2024 we as a society have a different understanding of sexual assault of boys and men that maybe was not part of accepted judicial proceedings in the 90s?
Correct, Jake. That's all part of it. So there's a couple of different avenues here that the Menendez brothers are pursuing, and Jean laid it out. One is what's called a habeas corpus petition. That's basically the last chance for any criminal defendant to attempt to overturn their conviction or their sentence. That happens after every other appellate relief has already been done and denied. Then, on the other hand, we have California, where the district attorney set up a resentencing task force. And that's where what you just brought up is very relevant. It allows factors to be taken into consideration, such as whether or not the individuals were subjected to psychological, physical abuse, whether or not there are factors today that would be looked at differently as opposed to when the conviction occurred. Also, there's a reason why there's such a focus on how the Menendez brothers behind bars rehabilitation.
And Jean, let me bring you back also, just because I wonder, a lot of folks who aren't as expert on criminal defense proceedings as you are, let's just give me, I'm just going to give you a hypothetical example. Let's say that there is a woman who has been raped and she kills her rapist. She still might go to prison, but the fact that she was killing somebody that had caused her grievous harm, that's factored into the sentencing?
Well, let's say that it happened right at the moment that a crime was being perpetrated upon her. That can be a manslaughter. That can be something that is not life without the possibility of parole versus a premeditated killing. This was a premeditated killing. They tried to get guns in Beverly Hills, didn't work, went to Orange County, finally San Diego, 3 hours away from Beverly Hills. They bought 2 shotguns. They talked about it for a long time. They planned it. Now, the defense, Leslie Abramson, very famous attorney, she said afterwards that the defense was fear. They were in fear of their parents, which Jake brings another issue. There are 2 life sentences here. The father, let's say he did abuse the sons, that's fear right there. But the mother didn't do that. She didn't sexually abuse them. And the defense was, at the time of the trials, they believed she knew. But they killed them both at the same time.
And Misty, what do you think this decision will be? I mean, there are news reports suggesting that the district attorney is going to urge a resentencing hearing.
Well, and that's exactly what Jean just said. It's looking at it through the lens of today. Would this have been a voluntary manslaughter? And if it were a voluntary manslaughter, then the sentence would have already been served because the maximum amount of time that could be given was already served. Now, Jake, I would have told you from the beginning, this is a long shot. But the way that the district attorney has been handling this case, it indicates that there may be a positive result for the Menendez brothers. Does that mean that they get out immediately? No, it could be a recommendation for what's called an indeterminate sentence, meaning they're eligible for parole, and the parole board would ultimately decide if they're able to get out of jail before their sentence is complete.
But Misty, what about what Jean just said about the fact that the mother didn't pose any violent threat to the sons, and they killed her too?
Well, yes, Jake, so that is a great point. And the district attorney is taking all of that into consideration. And we've always lumped them both together, both the victims and the defendants, in every single discussion we've had about this case. However, it is absolutely a factor that will be taken into consideration by the district attorney. And keep in mind, he's not the final word on it. He will make a recommendation, and the judge could probe into those issues as well. Ultimately, when a decision is made, a judge has to sign off on it.
All right, we're standing by for the district attorney to step up to the podium there. We're going to squeeze in a quick break.